Roll call, please.
Chair Paris. Vice Chair McLaren.
Here.
Director Bryden.
Here.
Director Galandri. Oh, excuse me. Director Urosic.
Here.
Director Knudsen.
Here.
Director Martin.
Here.
Director Recca.
Here.
Director Hogan. Director Kabar. Okay, and then from the Hallmark Group, we have Jim Beck with us here in the room. Jessica Alwyn is not present. I myself, Josh Montoya, am here in the room. And Phyllis is not with us, but we do have Arden Wells.
Yes, here.
Okay. Here in the room, we have Craig Martin.
Here.
And online, I believe we have Cameron Goodman.
Here.
Okay.
Okay. Adoption of the agenda.
I move to adopt the agenda. Second.
Okay. I have a motion and a second. All in favor say aye. Aye. Okay, that motion passes. Now we will go on to public comments for non-agenda items.
Yes. How you guys doing this morning?
Good.
Oh, good, wonderful. My name is Benny Moore, and I've been coming to these meetings for probably about 11 years, 6 years or something like that. And here lately, I've got another letter from Mr. Craig Portman, the general attorney for the Watermaster Board. I have one letter that came March the 19th of 21 that was telling me that I didn't have any water and some other charges. And I have another letter that I got from him March 27th of 23, quite a distance apart. But he's saying that I didn't have water and what have you. And I've sent a lot of mail to this office, registered mail, documented by the post office, and a lot of green slips that you get, stating my position on the water, that I was under a railroad land patent, under a land patent, under the railroad, whatever the railroad had at that time. I didn't know. But in between time, I tell you what I like to do. I like to read you a little note I got here, and then we'll go from there. Dear Mr. Craig Portman, Antelope Valley Watermaster, suppliers and board, I would like to express my disappointment at a lack of knowledge of my treaty land patent rights, which were granted by the Southern Pacific Railroad and confirmed by an act of Congress. An assignee, whether he is the first, second, third party whom the title is it conveyed, shall lose none of the original rights, privileges, or amenities of an original grantee of a land patent. As stated in the United States Constitution, Article 1, Section 10, no state shall impair a private contract upon these rights. Furthermore, these rights are not bound by the judgment in the adjudication basin of the Antelope Valley or the state. These rights of a land patent are governed by the statutes of laws of the United States and governed by an act of Congress. Despite my numerous attempts to bring this matter to your attention for a number of years, which is all documented by the registered mail through the United States Post Office, the Watermaster and Craig Portman continue to ignore my rights, causing me significant hardship, discomfort, and now monetary loss. I will be asking for any and all monetary, detectory, injunctive, slander, and all damage relief for that is caused by your actions. If this harassment continues. We never consented to the courts, any jurisdiction. We will not give up our water rights that we have, nor can you take away water rights that you do not know we have. I have the same rights as many other Antelope Valley water holders and more due to my land patent. We have the right to pump water as we please as long as it is for beneficial use, according to my land patent rights. These rights have been through the appellate courts a number of times and then to the United States Supreme Court when these rights, patent rights, prevailed every time and can only be overturned by an act of Congress. The state cannot make a contract upon a land patent no matter what. A land patent cannot be added to or taken away from. The state has no authority as far as this type of land patent. So if you wish court action, you will have to make an attempt to take me to the United States Supreme Court. The appellate courts have said they do not wish to visit this matter again. Also, all documentation has been sent to Judge Kamar, affiliated judges, and parties of interest. Despite presenting certified documentation of my land patent from the Bureau of Land Management, the Watermaster Board and Counsel Craig Parton have refused to acknowledge my rights. I am willing to come in and present any documentation or ask any questions you may have, as I have done before. I have talked to a number of attorneys that have practiced law for over 40 years, and many of them have said they have never seen or heard of a land patent. I received a copy of this land patent in June of 2021. I also have consulted expert constitutional law patent lawyers on this matter. If you need professional help, do not hesitate to reach out to a constitutional lawyer that knows about treaties. This is a treaty. Please understand that I'm only obligated to treaty law patent facts. Treaties are international law until you can prove otherwise. Again, I state, a state cannot make a contract upon a treaty land patent. I will continue to exercise my rights as granted by the United States government. I have enclosed documents again. They may help you understand my position, and I hope you can read it with an open mind. Therefore, I am requesting a retraction of your letter that you emailed me on March the 19th, 2021, and March the 27th, 2023, regarding your position that I do not have water rights. In conclusion, I have tried to keep this matter in Antelope Valley, but this Watermaster Board is forcing me outside. What is clear is that the Southern Pacific Railroad, which is now known as Union Pacific Railroad, is under a treaty land patent from the United States government, and through that adjudication has no power over the water rights of our property. So please refrain from sending me any more letters or telling me that I do not have water rights, as they have been confirmed by the highest court in the land, which you have refused to acknowledge. I will lease and sell my water rights as I see fit, and I hope we can resolve this matter with no further conflict. Saying that, I also would like to, I put a deal of a statue in front of quite a few people's desks there, and it states quite a bit of stuff. The Pacific Railroad is the second biggest landowner in the United States, and they're the number one oil exporter. They have a treaty land patent with the United States government. That same exact treaty land patent covers Benny Moore and Annette Moore's land. Your fight is not with Benny Moore and Annette Moore, but with the Union Pacific Railroad and the United States government and its land patent laws. The railroad is not listed in the adjudication of the judgment. And through an act of Congress, again, they are not under state jurisdiction. I advise you to take a look and read the treaty land patent jurisdiction law. Also read the statute below. I'd like you guys to do that. And with that, also have a true copy, certified by the Bureau of Land Management, is a treaty. And if you guys would make another copy, I brought copies in the office, and I've met with people in the office here, and you guys just don't seem to want to acknowledge it. And also, I hired a lawyer in 2017 that presented the same type of information to you, but without the land patent. But we did know that we were under the railroad's rules and regulations in their patent, or whatever they had at that time. And we since then got the patent, and I'll give you a copy of the patent that has certified officer, public information, the Bureau of Land Management, certified by an officer of the Land Patent Office, the Bureau of Land Management. His name is on it, and it's marked June the 29th, 2021. So there's not much more I can do. And I also have some other information from the Bureau of Land Management. So your fight is not with me as far as my water. Your fight is with the government and Union Pacific Railroad. Mr. Craig, I'd like to thank everybody for their time, and that's my deal. And what I'd like to do is present this land patent to the chairman and some other information here. And also, when the land patent gives a patent on property, they survey the property. This is a copy of the total survey of the property in the area. And I'd like to give some more statutes that the first attorney sent you guys in 2017. There was some statutes and also a letter designating the property and telling you what was going on. So I'd like to present this to the chairman, and she can give it to the attorney or whoever she wishes.
All right. Thank you.
Thank you very much.
Thank you. Okay, is there any other public comments?
Would anybody have any questions or anything? Not at this time? I understand.
Thank you.
Getting old, I'm slow. I just wanted to take a second. This will be my last Watermaster meeting, retiring as of Friday. And so I just wanted to say bye. It's been a pleasure being part of this whole operation, getting it started and seeing how it's flourished and moved on, and been able to address many of the issues that we have in the Antelope Valley now and into the future. So just wanted to say goodbye and wish you all the best as you move forward in making sure that the basin's well maintained. And don't forget that ABEC has an obligation to serve replacement water to all the customers within its jurisdiction. So therefore, thank you very much.
Thank you.
Thank you, Dwight.
Okay, is there any other public comment? Okay. Do we have online people?
I'm not seeing any comments online.
Oh, you're looking for it. I did. Okay, so you would let me know. Thank you very much. Okay. In that case, we will go to the consent calendar. Consent agenda. A is the financial report and payment of bills through March 31st, 2023. B, minutes of March 22nd, 2023, regular meeting. Do I have a motion?
I'll make a motion to approve the consent agenda as presented.
Okay.
Okay.
Do I have any public comment? Hearing none. All those in favor say aye. Aye. Motion passes. Okay, now we will go to number 6, which is our advisory committee report. And that will be Chair Chafin.
Hi, good morning. This is Dan Clifford. I'm going to play the role of James just for this morning. The summary of the advisory committee board meeting, which took place last week, is set forth at page 26 of your board packet. There were 9 members voting, or at least present during the meeting. We had what I would consider to be some productive conversation. And if anything within the summary piques your interest, I'm happy to provide some additional color. However, the summary, I think, is a fairly complete recitation of what took place during the meeting. And with that, I'll submit.
Thank you. And we shall go to number 7, our administrative committee report. And that will be our administrator.
Thank you, Chair McLaren. We did hold our monthly administrative committee meeting last week. Directors Hurosik and Bryden participated in that, and I think most of their actions are covered by the rest of the board items. If they have any particular items, we can discuss those. We did get a question from Director Knudsen, who wasn't able to listen in on that, and it was a question about how our cash flow is doing and where we're at as far as assessment. I could pull that up now, or I could do it under the administrator's report. Jacqueline Harris, our CFO, and the staff member handling that is available now. It's at the displeasure of the board, which you'd like me to do.
I'm good with the administrative report.
Okay, we'll cover that under there.
Yes. Okay.
I did have one comment that I brought up during the admin meeting, and that was towards working with our bank and understanding, our current cash balance. Good question, but what's insured and uninsured, and how the bank, how staff is looking at from a cash management and fiduciary responsibility. So I don't know if there's anything to report yet, Jim, or you're still working on it.
Go ahead.
We're still working on that. Yeah.
Okay. Then we will go to number 8, which is the update on delinquent annual reports, and that's our administrative staff.
Yes, thank you, Chair McLaren. So I am happy to pull up the list, but this is accurate as of April 12th, 2023. Anything submitted after that, it would still be marked as delinquent on this list. If you'd like, I can go through a majority of the people on the delinquent annual reports, but this is also going to be included in the upcoming annual report. So all the previous delinquent reporters are available on the previous annual reports for you to review.
What's our pleasure? You wanted to go over it, or everyone good with?
I'm good with it. So this is submitted in the packet.
Yeah, my only point was significant, and through staff and council, as this board, that we need to put together a game plan to resolve this. We have a lot of bad actors, some of them prolonged, some of them new. That's a key to our process of making sure we have a balance basis.
Yes, I'll just note, Director Urosic, that we have power under the judgment and the rules and regulations to enforce the lack of production reports that have been presented. So I think there's a escalating process that can be engaged in to encourage people to do it voluntarily.
Thank you. And someone from the public online reminded me, so I'm guessing everyone to speak up when we talk, so I will make sure I do that.
I don't know that it needs to be now, but could you provide a summary, high level overview of those, what enforcement options we have?
I'll do that at the May meeting. But we have everything from court intervention down to writing the letter to start the process. So then I'll be happy to make sure I give you the full list in May.
Thanks.
And are you good with that? Justin.
Oh, yeah.
Yeah. Okay. Yes, thank you. Thank you.
And
Okay.
I got a quick question. Is one of the conditions of any transfer that they are current on their production report?
That's correct.
That is correct. And so all the transfers being recommended today are up to date?
That's correct.
Thank you.
Okay, so sounds like we're going to get more information on our enforcement and delve a little bit more into that next month. All right. Number 9 will be our update on our annual audit, which also is our administrative staff.
And Jacqueline Harris will be speaking on this topic. Jacqueline, if you are speaking, you are muted.
Can you hear me now?
Yes.
Yes.
Okay, thank you.
Jacqueline, are you there?
Yes, can you not hear me?
We could hear that.
We can
part.
hear now, yes.
Okay. My apologies. I got a new computer over the weekend, and I did have some feedback yesterday in a meeting that that it's cutting out, and I've yet to resolve the conflict. So I apologize. I will continue, and if you don't hear me speaking, please let me know. The current year audit for 2022 is underway with Fedek and Brown, and is moving along fairly rapidly, with no issues noted as of yet. With respect to the memo for the audit of the previous year, my assumption is that you've all read the update on the annual audit with respect to 2021. And if there are any questions, I will take those now, short of rereading the memo. I don't know that that's necessary.
Are we good with that?
Yeah, it was good memo.
Okay. It sounds like everybody is okay and approves of the information in your memo. So thank you very much for that.
I do have yet to discuss these variances with the auditors and the course of correction, whether whether a restated financials or a prior period adjustment issued, that is still yet to be determined. So that was just a final note with respect to this audit memo, how these variances will be handled in the current year.
Okay, great.
And if I could, Chair, I think one of the most important takeaways from this is previously the board had asked staff to work with Fedek and Brown to seek reimbursement for Hallmark's time attributable to identifying and responding to the 2021 audit discrepancies. And thus far, they have been unwilling to cooperate and reimburse us for that work. And Jacqueline, please correct me if I'm wrong, but as of now, we still have not received a response from their manager, Mr. Badesko, requesting a meeting with Christopher Brown, which is the managing partner.
Right. The Fedek and Brown, Mr. Abadesco and Mr. Brown, are firm on their position that management approved the audit prior to issuance, that Antelope Valley Watermaster Management approved the audit prior to issuance, and that the audited financials are the responsibility of the management, and therefore they don't have a responsibility. I don't agree with that because of the gross errors that were made, and I do believe that they did not follow generally accepted auditing standards in performing their audit procedures. So the next step, in my opinion, would be to consult with legal and see what road we want to go down with respect to that.
Do you have any comment or direction, maybe?
Well, I've got lots to say.
Okay.
We're just have a closed session, just for considering election.
It would be, if that's the wish of the board to discuss that. We'll do it next month in closed session.
Okay. All right.
Is there, if I may,
Yes.
any consequence to having this discussion next month or not being today?
Jacqueline, this is Jim. I don't believe there's any consequence for us. We have the cash to handle the additional cost internally. It's that reimbursement, and we'll continue to work on the audit that was already in progress with them, mindful of the concerns we've already identified.
I concur with Jim's comments. Thank you, Jim.
The ability for the auditor to actually perform the 2022 audit.
I'm sorry, I couldn't quite hear that.
Talking loud. Normally, so I'll try that again. Is there any issue because we have an 8 question on or contested 2021 audit that it would impact our ability to execute the 2022 audit?
That is certainly an issue, but the outcome of which is undetermined at this time. It's there. I can see, for example, I can see a situation where if we decide to pursue legal action against Fedek and Brown, they would become independent. They would that would compromise their independency, and so they would not be able to perform to issue the report for 2022.
Okay, thank you. I do agree that we should probably dig in closed session as well. Less just options.
All right. And we will move to number 10, which is an update on amendment to the rules and regulations for repayment of delinquent RWAs. And that is our staff general counsel.
Yeah, I'll handle this. There's nothing to do on either number 10 or 11. You've seen these memos. This is the third time. And part of that was we had to go back to AVEC and clarify what they meant in their enabling legislation, that we weren't contradicting it in our new production memo. We posted, and the administrator posted these amendments and these memos to the website on, I believe, to give 30 days notice before our May meeting. So we'll have a public meeting in May, open session, and then vote on sending these to the court for approval. I don't think they're particularly controversial. We've talked about getting the replacement water synced up to when the replacement water is actually purchased, so there's not a shortfall there. And the new production limitations are consistent with the judgment. We've gotten no comments from the public or anyone else in terms of edits to it, but happy to take questions or field questions from the public about either one. But there's no motion necessary on either 10 or 11.
Okay, do we have any questions or comments?
I do have a question. What's the time frame for public comment?
30 days.
30 days?
Yeah. We would amend these slightly during the board meetings, and then that started the 30 days immediately, and then we had a board meeting on the 29th day, and we couldn't get the proper notice out. So we've got proper notice now. May we'll have the meeting, the open public session, and then from there we'll take the vote of the board.
No. Thank you.
Okay.
Okay, any other? All right, then we will go on to number 12, which is consideration of possible action on transfer application. This is engineering. We will start with R23-27.
Yeah, let me start. I received a letter last night, an email from counsel for Craig Van Dam, asking that the matter be tabled for 30 days. I believe a representative of counsel's office is either in the audience or on the phone, can confirm that that is the request of Mr. Craig Van Dam, that the transfer application be deferred another 30 days. Is counsel on the line? Can they confirm that that is the request of Craig Van Dam's counsel?
Yes, this is Kimberly Rose McCaslin from Derryberry and Associates, and that is an accurate representation.
With that, my recommendation to the board is that they table this for 30 days, and we take it up at the May meeting.
Okay, do we have a motion to table? Do we need a motion?
No.
Okay, that's right.
No, if you table it.
It's just each of us,
And it does look like one of the parties associated with this transfer is on the production report link with us.
They submitted it after the date.
Yeah. Okay. Well, that's good. That's it.
So I'll go down there. Are you okay?
Yes.
Yeah.
I'm okay.
Okay. So with that, we will table that one for an additional 30 days till the next meeting. Okay. And we can go on to BR23-30.
Hi, good morning. This is Arden. Phyllis is unable to attend the meeting today, so I do just want to note that I'm the sole representative of Todd Groundwater and the Watermaster engineer today. And so with the High Desert Dairy application tabled, we have 3 transfer applications today. The first one is Antelope Valley Water Trust to Tudor Perini Corporation. And this is a transfer of 1 acre-foot per year of permanent production right and 100 acre-feet per year of, 100 acre-feet of carryover water as a one-time transfer. And both Antelope Valley Water Trust and Perini use their water for investment purposes and do not currently have any extraction points associated with these rights. So because there are no identified extraction points, then we are unable to perform a material injury analysis on this transfer. So it is noted that we recommend that a new point of extraction application or a subsequent transfer application is required before any of this water would be produced by Tudor Perini. Tudor Perini is not a part of the judgment, and so they would also need to intervene in the judgment and become an Exhibit 4 party as a condition of approval. It was brought up during the advisory committee meeting, question about long-term production if this water is used for construction. And I just want to note that whenever any applicants submit an application for water that would be used for construction, we try to get an estimate of annual production associated with the project, whether that's domestic use or operation and maintenance water. And then the last thing to note is that this is one of 2 transfers that are going to Tudor Perini Corporation that are up for consideration this month. The second one that y'all will hear of next is for 140 acre-feet of carryover water from Crusoe Investments. So in summary, this application does not have any points of extraction associated with it, so we could not perform a material injury analysis. But we do request that before any of this water is used, then Tudor Perini will need to submit a new point of extraction application or a subsequent transfer application. And additionally, they will need to intervene in the judgment to become an exhibit for party before any of the carryover water can be transferred. And this was approved by the advisory committee. Are there any questions?
Any questions? Do I have a motion?
I'll move to approve resolution R23-30.
Second.
Okay, I have a motion and a second. Is there any public comments on this item? Hearing none. Do I have a motion to approve? All in favor, say aye.
Aye.
That motion passes. Okay. Now we will go to R23-31.
Thank you. This transfer is from Crusoe Investments, LLC, also to Tudor Pruney Corporation. So Crusoe has parcels in the central Antelope sub-area, and similar to the last application, the extraction location for Tudor Pruney is unknown, so no material injury analysis could be conducted. We listed in our letter 3 conditions for approval of this application. The first would be the approval of a transfer permanent production right, which just occurred with the Antelope Valley Water Trust. Similarly to the previous application, Tudor Pruney must successfully intervene in the judgment and become an exhibit for party in order to receive this carryover water. And similarly, they must submit a new point of extraction application or a transfer application prior to any production. Are there any questions?
Sounds like there's no questions. Do I have a motion to approve?
Motion.
Do I have a second?
Second.
Okay, I have a motion and a second. Is there any public comment? All in favor, state aye. Aye. That motion passes. Now we will go on to number D, R23-32.
Thank you. So this is a transfer from Palmdale Water District to Little Rock Creek Irrigation District. And it's for 250 acre feet of 2023 current year production right. So this is a one-time transfer. Both parties are Exhibit 3 parties. Palmdale Water District has about 2,800 acre feet per year of permanent production rights, as well as unused Federal Reserve rights and imported water return flow rights. And their production is split among 23 production wells located in the central and southeast Antelope subarea. And Palmdale Water District produced about 8,500 acre feet in 2022. Little Rock Creek Irrigation District has about 800 acre feet per year of permanent production rights, along with their unused Federal Reserve rights and IWRFs. Their production is split between 4 wells in the southeast Antelope subarea. In 2022, LCID produced about 1,150 acre feet. So in September of 2022, Palmdale Water District and Little Rock Creek Irrigation District formed an agreement in which LCID will transfer their Table A State Water Project surface water to Palmdale Water District in years with 20 or less % of State Water Project allocations. So with this agreement, they agreed that Palmdale Water District can pay back LCID for this water via groundwater transfer in lieu of a financial payment. So this 250 acre foot per year or acre foot transfer is the groundwater transfer payment on 100% of LCID's Table A water. So during years in which LCID transfers surface water to Palmdale Water District, Palmdale Water District's groundwater production is reduced and supplemented by surface water. So they will be decreasing their groundwater production, and any increase in groundwater production by LCID will be distributed among their 4 wells. So the drawdown won't be focused in just one area from this additional production. Because this transfer results in a shift in the location of groundwater production with no overall increase in production, and because any increased LCID production will be spread among 4 wells, there is no material injury associated with the storage and sustainable yield related to this application. And Todd Groundwater recognizes that this application represents no new production and finds material injury to be negligible. And this was also approved by the advisory committee.
Okay, any questions? Do I hear a motion?
I'll second it.
All right, I have a motion and a second. Do I have any public comments for this? Okay, all in favor, say aye. Aye. That motion passed. We will go on to 13, which is consideration and possible action on new production application.
So I have some of the slides that Phyllis had prepared previously related to this application. I also wanted to see if our council wanted to say anything about this application, either before or after I provide the introduction and material injury analysis.
Let me say a few words about new production applications in general. I thought before this matter got into the details of it, you were aware of rules and regulations and the judgment that impact new production applications. This board approved rules and regulations almost 2 years ago that deal with new production applications that give the board substantial enforcement powers if the terms of a new production application are violated. If they are exceeded by a certain amount over 2 consecutive years, the board has the power to revoke the application. I just want you to know that approving a new production application isn't the end of the story. There's important follow-up to be sure that the place of use is where it's indicated in the application. The reasonable and beneficial use has been found by the engineer, and there's no material injury that's found by the engineer. And remember, that replacement water assessments are paid for each acre foot of new production. That's all I wanted to say, just so you kept that in mind as you consider and have dialogue on this application. Thank you.
Thank you, Craig. Can y'all see my screen where I have item 13 on the screen?
No, not yet.
Well, okay, let me try this. Okay. Now can you see my screen?
Yes.
Good.
Okay, excellent. So for this new production application, just to provide a background summary, this is for Barrel Springs Properties LLC, and they are proposing a development that provides both farm worker housing and...
Do you mind if you make it just the one slide versus the 2, so we can see it?
Okay, how does this work?
That's much better.
Okay, excellent. I'm not able to bring it up full screen, but this should work for now. Excellent. So they have proposed a 58-acre farming and farm worker housing development community. And they're requesting 120 acre feet per year of new production, in which in their application they listed 9.8 acre feet per year for domestic water use and 108 acre feet per year for agriculture. So this is located down in the southern basin margin and just south of the California aqueduct. And we have very little data in this area concerning groundwater levels, and it's an area with very little production currently. It is within Palmdale Water District service area, but the parcels on this land are not currently being served. The parcels directly north of the property on the other side of the aqueduct are being served by Palmdale Water District, so it's unlikely that there are any domestic or private wells in that property. Looking at aerial images, there are some what appear to be homes towards the east and the west of the property, but they're about 3/4 of a mile away from where this well is proposed. So it's not believed that there are any private wells adjacent or very close to this parcel. So when we think about the geology in this area, there is a high level of uncertainty of exactly what the conditions are beneath the parcels. The parcel is within the San Andreas fault zone, and often faults are thought of as kind of one linear fault going through the surface, but this zone is a lot of smaller faults and subparallel faults that are kind of tearing up the geology in that area. And when there is a highly faulted area, faults can impede or redirect groundwater flow. They can act as hydrogeologic barriers, where groundwater pumping on one side of the fault can have less of an effect on groundwater on the other side of the fault. Or they can kind of act as barriers where the drawdown is more pronounced at wells that are near the fault. And it can affect the overall connectivity of the groundwater in the area. And so going back to the slide, to the left, there's the line showing where an existing geologic cross-section that we have is, and that's about 2 miles northwest of the parcel. And our understanding of the geology in that area shows that there's shallow bedrock and then these shallow alluvial deposits on top of that. And generally, the groundwater is going to be pumped from the shallow alluvial deposits. This, in turn, can cause many of the wells in the area to have low yields and be unable to pump high volumes of water. However, because there are so many faults in the area and this is an understanding from about 2 miles away, we don't have a strong geologic understanding of exactly what the aquifer conditions are in this area. So when we think about material injury, I want to give a little summary about what we have considered in this area. The first item is groundwater levels, particularly groundwater levels in surrounding wells. And we do not have historical monitoring near this parcel, so we can't really draw any conclusions about how water levels have been changing or if they've increased or declined in this area. However, we can think about, are there nearby wells? And based off of the aerial images and the properties that are serviced by Palmdale Water District, we do not believe that there are wells directly near this property that may be strongly affected by drawdown from pumping. Another consideration is change in water quality in surrounding wells. And similarly, we do not see nearby wells that could be affected by any changes in water quality from increased production in this area. Another material injury concern is subsidence, and this area does not have any historically observed subsidence, and because it's a lot of bedrock, it's unlikely that any subsidence would occur. For changes in storage, the requirement to have the well metered and then the agreement to pay a replacement water assessment for any water produced will make sure that this is not decreasing storage in the basin and the central Antelope sub-area. So given all of this information, our evaluation was that a material injury is not expected from this new production. And additionally, we have requested that there is an aquifer pumping test associated with the installation of this well. We have very little data in this area about aquifer conditions or about the effects on faulting or generally about the yield of wells in this area. There is a possibility that the well will not be productive enough to produce 120 acre feet per year. But considering material injury, having the well not be productive is not a material injury concern for the aquifer and the adjudicated basin as a whole. So with that, I thank you for listening. And if you have any questions about material injury or the hydrogeology, I'm happy to answer them.
Is there any questions or comments?
I have a question. Wouldn't it be ideal to have that information regarding the well testing before we approve the resolution? And this is for Todd.
Yes, so I did discuss with the council about if it would be appropriate to review the well testing as a condition for approval. And when I really thought about material injury and our analysis, it seemed that if the well test showed that the well did not yield much water, that is not a concern for material injury in the surrounding areas because there are not nearby private wells that would likely be affected by that.
Thank you.
You're welcome.
I think there's representatives from Beryl Springs. I'd like to hear them speak if they have any comments.
This is Toby Waxman. I'm with Entitlement Strategies Group, Inc., representing Beryl Springs Properties. We are a land use entitlement consulting firm. And so,
Can you speak just a little bit, please?
I sure can. Can you hear me now?
That's better. Thank you.
Thank you. Okay, so with regard to the conditions that are being proposed, Beryl Springs is fine with the conditions to ensure that there's water, with the exception that they are in the process of acquiring the land, and they actually have acquired a permit, has been issued from LA County Environmental Health to do a test well. And so what if they have the water, even if the water is there, if they don't have the rights to take the water out, then they would be spending, what it costs to do the test well in advance without even knowing if they have the ability to take the water out, even if it's theirs. They absolutely are prepared to go forward with the test well once they know that they have the rights to the water if the water is there. And so they are looking to the Watermaster Board for its approval of the rights to be able to have the water and use the water that meets their needs Once they have that, they are scheduled to go forward with the test well right away. Obviously, if there isn't the water and to use, the project likely would not go forward. But they don't want to go forward with a test well only if the water's not there. They've gone through all of this all for nothing. So they're asking the Watermaster to please approve their application. Once they have your approval, then they will go forward with the test well. They also understand the concern relative to the conditions that are outlined in the new rules and regulations in item number 11. And they are in agreement that if you wanted to place such a condition on their approval, they are in agreement with doing that. And I believe their counsel has submitted a letter to that effect within the last day or so.
I don't know if it's proper time for me to speak.
I'm done. Go ahead.
Okay. Good morning, board members. I'm Nathan Metcalf, representing the developer, the people's concern related to the proposed development and new production application at the Barrel Springs property. And I agree with the comments by Toby Waxman. This application was first before the board in September and has been subject to multiple delays. These delays have proven to be very costly to my client. I think any further delay would just add additional cost to this project. So I would request that you don't delay in acting on this. It appears that the record in this matter indicates that the application meets all the requirements of the judgment and the Watermaster's rules and regulations. As we just heard, the Watermaster engineer has recommended approval of the project. They found that the requirements for new production in section 18.513 of the judgment has been complied with. Specifically, they found that my client has agreed to purchase replacement water, which will be a condition of approval. All conditions of the new production are met under the judgment and the Watermaster's rules and regulations. No material injury as defined under the judgment will result from the proposed production, and there will be no impact to the basin. Likewise, the advisory committee has recommended approval. And in our review of prior determinations of the board, when conditions of new production are met and there's a recommended approval by the Watermaster engineer and the advisory committee, this board has always approved new production. Based on a record in this matter and the prior actions of the board, it would be arbitrary in this case to deny the new production application. Therefore, we respectfully request that the Watermaster approve the application.
I've heard from legal counsel from the permittee. I'd love to hear back any comments that you have, Craig.
Yeah, my view of this is that there's been compliance with the technical terms of the judgment and the rules and regulations. The engineer has made a determination this is reasonable and beneficial use, that there's no material injury, and so I think this board has got its charge in front of it and what it wants to do. There's no impediment to, I don't think, to voting on this topic today. We put it off a couple of times. They've complied with what we've required. And my view of the rules and regulations and the judgment is they've got compliance with those terms. If there's a production well that is not sufficient to sustain the project, then it will go away on its own terms. Anyway, that's my take of this. Yeah.
I got a quick question for the advisory committee. Dan, are you still on the line?
I am here.
All right. So in the advisory committee written report, it sounds like there was some discussion on this item. Can you elaborate why we had 5 abstain on that vote and only 3 in favor?
Yeah, I don't have any visibility in terms of why individual members elected to abstain versus vote up or down on it. Some of the comments that were made during the call related to wanting to make sure that if it was approved, there would be a side agreement or acknowledgement that the water, I don't want to necessarily call it a water right, but the ability to extract water was conditioned on the availability of water, replacement water. And that's where a lot of the heated discussion took place. There was, I would say that there was no resolution on that issue. People made points on both sides of that issue in terms of the need for a side agreement versus the potential application of one of the resolutions that's being considered today as it relates to the revision to the rules and regulations to more clearly indicate that the ability to extract water was conditional. And that's kind of where the discussion went. I voted in favor of approving it for some of the same reasons that Mr. Parsons has articulated today.
All right, thank you, Dan.
Sure
And then
thing.
I've got one more question for Arden. So Arden, I apologize if you've discussed this in past meetings, but you showed a cross section of where this project is and the fault lines, and then there's like a shelf that drops off to the basin. Is there any concern from the Watermaster engineer that replacement water provided for this project is, we know it's not going to reach the location where the new production occurs. It's going to be further north into the groundwater basin?
Yes. So I think when thinking about replacement water reaching this area, my perspective is that if there is a level of hydrogeologic connectivity in which this project would be pulling from water in the main basin, then it would be possible for the replacement recharge to ultimately reach that area. When we think about the total storage, it's not necessarily in the basin and the overall sustainability of the basin. We are often thinking about the net storage. So it's not underneath, one particular area. How is that storage changing? But it's really looking at the basin health as a whole. There is a possibility that there is a level of hydrogeologic disconnection. And if that is the case, then the water that is extracted would not be decreasing the overall water levels as much if it's partially disconnected in the main Antelope Valley subbasin. And if that were the circumstances, then recharge water probably would not be reaching this area, but it is slightly, because it's above the bedrock, it is most likely that the recharge is coming from the mountains in the surrounding area, and it would be extracting water that would be feeding the Antelope Valley. And so any decrease in water coming into Antelope Valley from the mountain front recharge would be compensated for by recharge that is occurring in the recharge basins. So essentially, the water would be getting into the adjudicated basin one way or another, even if it may be from a different area.
Okay, thank you.
You're welcome, and let me know if I need to clarify more. I know that was a bit scrambled.
No, I think you did good. Thank you.
So you did do good. There's just a lot of words out there, faults impeding, little data on production, high levels of uncertainty, no historical monitoring, being able to pump the rate of gallons per minute they need to do this, and I will leave it at that. Is there any other discussions or questions?
I was able to listen in. I think you were on the advisory call? So,
yeah.
What I recall is, I think as Dan said, most of it was a technicality conversation around the the rules and regs, actually warrants. Rules and regs, and not really about the technical side. That advisory meeting, I think prior ones they did and worked through that. This was more of a legality and procedural.
Okay, any other questions?
One thing I'd like to make clear is the applicant indicating that they will abide by the amended rules and regulations that are in the two memoranda that were discussed today. I think we want to make sure that they are willing to be so bound by those, assuming they are enacted in a month. So there's no question that the memo amending rules and regulations as to new production and the replacement water delinquency memo, that the applicant would agree if the board votes in favor of their application to be bound by the terms of those amendments to the rules and regs. Is the applicant willing to be so bound?
Yes, this is Nathan Metcalf again. Yes, the applicant is. You should have received a letter April 24th from Claire Collins from my office at Hanson Bridge indicating that, so you have that in writing.
Thank you.
And that is my understanding as well.
Okay, is there a motion?
I think we still may need public comment.
Oh, yeah. I was going to do the motion and then do public comment.
Okay.
That's okay.
Are you asking for a motion?
So would you like to hear public comment first?
No, I will make a motion to approve the production application as presented and clarified by council.
Do I have a second?
I'll second.
Okay, I have a motion and a second. Is there any public comments on the item?
Not seeing any online.
All right, and I'm asking for a roll call vote on this one, please.
Chair McLaren?
No.
Director Bryden?
Yes.
Director Urosic?
Yes.
And Director Martin?
Yes.
And Director Knudsen?
Yes.
And that does not pass.
Okay. We will go on to number 14. Consideration.
Can I just, not to interrupt the chair, and I apologize. I'm curious from council, I don't know if we've ever had a no vote. The new production, procedurally, how we need to continue to have it. I don't think vanish away, or does it continue to be retabled?
It is a denied motion, and there needs to be unanimity to pass any motion, unless there's prior agreement that a topic can be subject to majority vote. So the motion as framed, the application as framed, is presently denied.
May I comment?
Sure.
My name is Robert Strock. I'm with the Global Bridge Foundation. We're assisting the people concerned. Given that we've been through this for 6 months, is it an unfair request to ask what the basis of your no is?
My answer is no.
Then if it's not unfair, I'd love to hear the no, or the reason for the no.
And I'm saying my answer is no.
So you're going to say no with giving us no reason whatsoever to understand your no.
I have that right. Is that correct?
Yes. I think she's answered to in the manner that she's chosen to answer.
May I say something?
If the chair will allow it.
Yes, I'll allow it.
Does the no relate in any way to the rules, to the requirements of the rules of regulations and the judgment requirements for new production?
I think that's asking for her to give an opinion that's in essence a legal opinion.
Therefore, that's why I'm not answering anything other than no.
Chair, unless you want to take any other comments, I believe you were ready to move on to the next agenda item.
Okay, so we will go on to number 14. Consideration and possible action on well application, and we are going to be doing a I was going to say a switcheroo, but I did kind of sound, we're changing board members so that we are having Rekha step in for Urosic. Thank you. All right. So consideration and possible action on well application for R2333.
Yes, so this application is for a replacement well for Bolthouse Properties LLC. The applicant is an original Exhibit 4 producer with a production right of 9,945 acre feet. The replacement well will be for agricultural use and will be constructed less than 300 feet from the existing well. The existing well will be destroyed, and the applicant will be required to provide the Watermaster with evidence of proper decommissioning of the abandoned well and documentation of meter installation on the replacement well. And if you have any further questions, I'm happy to answer them.
I don't have it.
Okay. If we have no questions, do I have a motion?
I'll move to approve resolution R23-33.
Second. Oh, sorry.
That's okay. We have a motion and a second. All in favor say aye.
Aye.
Aye. Okay, that motion passes. Now we will go on to R2334.
Thank you, Chair McLaren. This is the exact same application, just for a different location for Bolthouse Properties LLC. It will still be constructed within 300 feet from the existing well. The existing well will be destroyed, and of course, the applicant will be required to provide evidence of proper decommissioning and the documentation of the meter installation on the replacement well, similar to the previous application.
I also move to approve resolution R23-34.
Do I hear a second?
Second.
Okay, all those in favor say aye.
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 Okay, that motion passes. We're switching away. Thank you. Okay. All right. So we will go on to the administrator's report. Update on administration activities.
Thank you, Chair McLaren. As I mentioned earlier, this would be a good time for Jacqueline Harris to give you a quick update on cash flow assessment and some key financial indicators. So I'll have Jacqueline join us and give that update.
Can I be heard now?
We can hear you.
Yes.
Jacqueline.
Great, thank you. Okay, with respect to cash flow, there is some concern. It currently, and I will say currently, and what I mean by that is as of May 1, because earlier in the meeting the bills were approved, so net of that payment, beginning cash will be approximately $120,000 on May 1. And the variable assessments for 2023 will be going out. Our target is 1. And the assumption is that there will be possibly a 70% receipt on those invoices in June, and possibly a 15% receipt in July, and then 5 and 2 in August and September. The current receivables, there are still outstanding fixed fee assessments from the January billing. Invoices with delinquent charges have been sent out on the majority of those invoices that are still outstanding. I do anticipate that there will be receivables coming in June, possibly May, June, July, August, for those receivables. Expenses typically run approximately $90,000 a month. Given all of this information, it is likely, in my analysis, that possibly by the end of September, and certainly by November, there could be a cash deficit in the general account. The collection of outstanding receivables is obviously unknown. Collection efforts are being made, and in the analysis that I have done in the attrition of receivables on the variable assessments that will be going out, it does appear that possibly, I say September to November, within that period, we will have a negative cash balance in the general account. Any questions?
Just a question on that. Does that assume any settlements or payments of outstanding legal items that we're in court for?
I don't believe so.
It does not. It's a good question. It does. I haven't. My assumption is that those will not be settled, and the only reason I make that assumption is to be conservative on the cash flow.
Appreciate that. Do we have a dollar amount? I'm trying to remember in my head of what we have in suit to try to collect. It's significant.
With respect to
Jacqueline, Craig's going to answer that.
Yeah, in terms of, I think that's probably for a closed session.
Fair.
Yeah.
But significant.
Yes.
Any other questions? Okay, then we'll go on to number 16, the Watermaster Engineers Report.
Hello.
So for our Watermaster Engineers report, I first off want to say that we had our first sub-area management meeting and the advisory committee meeting last week. There were no public comments or questions, but we did remind everybody that in our annual report, we include an analysis of the change in storage in each sub-area as part of the annual analyses that we do. And I want to give a big thank you to everyone who has submitted data for the annual report in a timely manner. That is a huge help. We're plugging away on it and are set to get the draft annual report out to y'all in early June, as we do every year. I'm going to share my screen again and pull up the tables for our new production and qualified small pumpers that we share every month. There was no new production that was approved last month. So these tables are in the packet, but there's no change from last month. Next, I'd like to provide a very brief update on model development. We've been talking a lot about our work extending the model domain and updating the aquifer parameters in the areas that weren't included in the original USGS model, so that moving forward, our Antelope Valley adjudicated basin model can include the entire adjudicated basin. And so we are wrapping up that step, which is really exciting. Very soon we'll have that part of the modeling process completed, and then we'll be moving into the next phase, which is incorporating all of the data that we have about water entering the basin and leaving the basin, historically and present, to start populating that model with the data that we have collected over the years. This is not on the agenda, but I just want to note that we are in compliance with SGMA reporting. Our annual reporting and water level data reporting deadlines are a little bit different than a lot of the groundwater basins managed by SGMA that have groundwater sustainability plans. Our deadline for our annual report is August 1st, and we've been advised by DWR each year to go onto the SGMA portal before the April 1st reporting deadline and just say no data for now and submit a letter explaining that we're an adjudicated basin and our annual report and data will be uploaded by August 1st. So that letter was written and submitted, and it will be online on the Watermaster website in case anyone would like to see it. But there's really no differences other than the date in the letter from previous years. But we are in compliance. And with that, that is all I have. Let me know if you...
That I have a knowledge gap here. So for the model, model that you're is there any contemplation of a water quality component to that?
Oh, okay. Water quality component. From my understanding, there is not currently any work done relating to water quality. However, when the basin and aquifer conditions are understood a bit better or more accurately represented with our increased understanding in this model update, then it can be utilized to support water quality investigations in the future. Many of the water quality work tends to be more localized, but I'm sure that the aquifer parameters defined in the updated model can be utilized for more local studies, such as recharge studies.
And your model and information now, is that available to the public? So if someone were to request that information or another agency, could they get the source data for that? To tinker around with their own water quality thoughts?
Currently, I do not believe that it is available. Typically, whenever there are data requests, we need to check with the agencies that submitted any data in order to make sure that they're okay with that data being transferred.
Very good. Thank you.
You're welcome.
Okay, any other questions? Okay. Now we will go on to number 17,
Yes.
our general counsel
Yes.
report.
Most of this is subject to the closed session. Just a couple of updates. The matter that required the 2-day evidentiary hearing in San Jose is still subject to briefing and will be through May, and then there'll be a decision after that time and any consideration of an appeal. You've mentioned having the audit issues discussed in closed session, and we'll be prepared to do that and talk about delinquent production reports, and we will respond to that next month. There was an inquiry from council about whether we would allow council for board members to participate in closed session. And we want to bring this to the board's attention. We plan to look at this, see how we can do so without opening the door to all the attorneys that want to be in closed session. But we'll present that, I believe, in a memo form to discuss what the issues are and the options. It's a very valid interest. There's legal counsel for various positions on the board that would like to hear directly what's being discussed, so they don't have to depend on you all to interpret and remember the critical points. So we appreciate that. We just want to set up and potentially do this through rules and regulations, so it's a permanent, clear and unambiguous understanding of what legal counsel can be there under what conditions. So we'll do that. And the letter to Mr. Moore.
Can I speak to that?
Yes.
First I've heard of it. I guess as a landowner representative, you know, I have major concerns about that.
Yeah.
I represent all landowners in this valley. And there's no way you're going to want every landowner's lawyer, nor the landowners are going to want to pay for that. And then you have a separation of, just put it on record.
Yeah.
That's my opinion, and I may get yelled at by a council, but that's my opinion.
So noted, in a concern that we discussed with council, that you open the doors up to everyone to do so, but there may be ways to address that. There's one designated counsel for landowners. Whether there can be agreement on that is another question, whether we want to go down that road or need to go down that road.
I'll remind everybody that was here during the adjudication of how long that took and how to come to agreement, that the opportunity for that is slim to none.
Yeah.
But I think you had to address it, because I know there was brought to our attention to bring it to you to see what you thought of it.
Yes. And I wanted the board to know that inquiry had been made of me in the last week, and we'll respond and have dialogue about it.
So for him, feeling like he didn't know anything of it, it did come out of something we had to bring to you, so not to blindside you guys, to at least have it brought out that was asked. I want to keep the peace here.
Yeah, I understand the ask. I'm just giving you my opinion.
Right.
So noted. Then Mr. Moore's presentation covered the issues with respect to his position, and our letter to him is included in the board packet. That really is no other issues. The rest will be discussed in closed session.
would that be appropriate time to address how or what to do with this information?
No,
that earlier?
no, that doesn't need to be affirmatively addressed. There's no issue on the table with respect to
Okay.
that. No.
I just wanted to make sure.
Yeah. That's all I have to report on.
Okay. Unless we have questions for him, we will go to number 18, board members' request for future. We're not in a area for comments at this time, right?
No, if you'd like, the board would like to hear further comments from Mr. Moore, it's welcome to do so.
And board, what is your pleasure? Because I know I gave you longer than 3 minutes at the beginning. Hopefully that not to cut you off, but at this point in time, I think we gave you your time, and he just spoke, and we're going to continue on and go to our board's members' request for future agenda items.
I have one. I think it's the elephant in the room. We have to talk about our budget. We have to talk about our finances. We can't, there's no more road to kick the can down. So I'd like to agendize that for next time.
Okay. Any other agenda items?
You beat me to the punch.
And wasn't there something that they were asking for from the committee, and I had my papers all?
Oh, it was great. Thank you. So I am on. I did ask staff to, and I think they are evaluating, looking at our FDIC insurance for our cash balance.
Okay, because I knew there was something else right now. I got
Chair McLaren, I'd also have from the advisory committee, which I participated in this time, at least was able to listen in. I believe in their memo, they have one item that they asked the board to consider, which was an RFP for 2024 administrative services.
I think that's all tied in with the budgets and the fee and everything else. So to me, I think we can address that through that item.
Okay.
Yeah, without acknowledging whether or not we're doing it, right?
Yeah, correct.
Okay, so I think that covers different people that are important inputters of information. And so with that, we will go to closed session. Do I have a motion to go to closed session?
Motion.
Second. All those in favor?
Aye.
I think we didn't need that, but it's okay.
We do.